Mr. London.
Good morning. How are you? Hey, D Hall, how you doing, sir?
I'm doing well, man. How about
Talk to
you?
you. Welcome, welcome.
All right, brother. I couldn't miss this.
I appreciate it very much. Good morning, everyone. I appreciate everyone being on time and I respect everyone's time. So why don't we get started? So, you know what, normally I like our guests to get a pen and paper because you may want to take some notes. So I'll give you a minute to get a pen and some paper so you can take some notes. Here's one of the things I like to share with you as well. The information that you're going to hear today is not just for you, it's for your friends and family. Because so often people have so much misinformation and it just confuses them more than anything. So get a pen and paper, get some clear information, and when you get the opportunity, share the information with your close friends and family because it's going to be beneficial for them as well. Why don't we get started? So I am attorney Ted London. I'm an attorney here in Chicago. I know that we have some guests who are from out of state. My good friend Eric Hall is in Atlanta, and we have some of you in some other states as well. So to all of you, welcome, welcome, welcome. This is an estate planning seminar, and the whole objective of estate planning is to keep your assets out of probate court. Typically, for most middle class folks, we're talking about real estate and we're talking about your financial accounts. And when we talk about financial accounts, we're talking about checking, savings, mutual funds, 401ks, stocks, bonds, CDs, credit unions, life insurance policies, annuities. Those are the things that we want to keep out of probate court. Real estate, your financial accounts, and we want to keep you, the person, out of probate court as well. So when we talk about estate planning, really the number one objective to efficient estate planning is to, again, keep your things out of probate court. In that regard, we don't do wills, no wills, because if a person has a will, that will send their things through the expensive, time-consuming, stressful probate process. I know many of you are shocked by that because most people believe that if one has a will, that will in fact keep their things out of probate court, when in fact it's exactly the opposite. If one has a will, it will send your things through the probate process. So believe it or not, the first rule for efficient estate planning is no wills. Again, there are three primary things that we want to keep out of probate court. So let's start with the real estate. Now, when we talk about the real estate in avoiding probate court, we're talking about single family homes, multiple unit properties, commercial property, whether your property has a mortgage on it or not. All property should be in some sort of trust. So your property should be in a trust. There are several types of trust. One trust here in Chicagoland, we typically use what's called a land trust. If you have your property in a land trust has a number of benefits. The first benefit is you get to name who gets the property after you, and whomever you name will get the property very easily once you go to heaven without them having to go through the probate process. The second benefit of having the property in a land trust is if you have your property in a land trust, if you are ever sued, the judgment will not attach to your home. I'll give an example. We had one client, he was in a very bad accident. He told me he was driving back from Mississippi, and he said that he saw some guys cleaning up the side of the road, he said from about a mile away. As he approached the guys, one guy stepped out onto the road, he hit the guy and killed the guy. Horrible accident. Well, he was concerned that he was going to be sued and they would take his home. So he came in and we put his property in a land trust, because if he were sued, because the property were in a land trust, they would not be able to collect from his home. Fortunately, in that case, he had a substantial amount of auto insurance that covered the liability for the death, and they did not sue him personally. But had he been sued, because his property was in a land trust, the judgment would not have attached to his home. So that's another benefit to have the property in a land trust. It stops judgments from attaching if one is sued. Another benefit of a land trust is if you have your property in a land trust, there's a privacy benefit. If someone runs your name, they're not going to see what property you own. And if they run your property address, they are not going to see that you are the owner. So we get many elected officials, a lot of business owners, a lot of judges we have as clients, a lot of teachers, a lot of retirees, because they appreciate a lot of pastors, because they appreciate the privacy benefit. If you don't have your property in a trust, someone can just run your name and they can see any property that you own, or they can actually run your property address and see what property, who is the owner. So if you have your property land trust, it affords you a privacy benefit as well. So again, we want to keep the property out of probate court, single family, multi-unit, commercial property, lots, any property, vacation properties, any property that you own should be in some sort of trust. Here locally, we use a land trust with Chicago Title Land Trust Company. Has some benefits, keeps it out of probate court, stops judgment from attaching to your property if you're sued, and there is a privacy benefit. While your property is in a trust, you can still sell it, rent it, refinance it, do whatever you like to do. You are still in 100% control of the property. When it comes to who you're going to leave the property to, you can name whomever you want to leave the property to once you go to heaven. And they don't have any interest in the property as long as you are living. So you can leave it to all the kids, as I say sometimes, or just the good one. That's up to you. But whoever you leave it to, the others will not be able to contest it. It will be contest proof, as opposed to if you had a will, wills can easily be contested. So all property should be in some sort of trust. Now, for other of you who may live in other states, California, Georgia, some other states that I know some of you are listening from, then you would use what's called a living trust. And so living trust has the exact same benefits as a land trust. It's going to keep your property out of probate court. It's going to stop judgments attaching to the property. There's going to be a privacy benefit as well. You're going to still control the property 100%. And you get to name who gets the property after you, and whomever you name will get it very easy without going through the probate process. So an estate planning tool to keep your real estate out of probate court is a trust. All real estate should be in a trust, period. Now, if you don't put your property in a trust and you pass away, whether you have a will or not, it's going to go through the expensive, time-consuming, stressful probate process. I'll give a little secret. Lawyers love to probate your estate because probate's a very lucrative area of law for lawyers. And so if you have a property in your name and you pass away and the property is not in a trust, then the court's going to determine who's going to get your property. Typically, it would be a spouse or children. And if there is no spouse, then the children will share it all equally. Now, sometimes that can create a problem because sometimes the kids don't always get along together. Sometimes they're kids from multiple relationships, multiple moms. Sometimes some children don't have the financial wherewithal to cover some of the expenses of the home. Some of the children have personal issues, whether it's
crazy
healthcare issue, substance abuse issues that can create a real issue for the others. But notwithstanding that, they will still have an equal interest in the real estate. And what I see when that occurs is, again, it creates a lot of problems, a lot of extra expense for your loved ones. And oftentimes I see it causes the property to be lost because you have the one child that's paying the expenses, the others don't have the financial wherewithal to pay. And then the child that's paying, they get a little frustrated with paying all the expenses and they stop paying, and then ultimately the property is lost. We see that far too often. So you have worked so hard to acquire your property, pay it off. You definitely don't want it to be lost 2 or 3 years. after you pass away because of some mismanagement of one or more of your children. So that's why I say sometimes you may want to leave it to just a good one because, or two or three. Some of you, all of your children are good, but they're going to be able to manage the expenses that's going to come along with the home ownership. So the bottom line, for the real estate, there should be in a trust, period. Okay. Now let's talk about how we keep you personally out of probate court, because you individually and your loved ones and your spouses can go through the probate process as well while you are living. So unless you have power of attorneys for yourself, and there are two kinds of power of attorneys, one for healthcare, one for business matters. If someone ever needs to be in a position to make decisions for you, and you don't have those, then they're going to have to go through the expensive, stressful, time-consuming probate process to be appointed your guardian. Guardianship proceedings, some of you are familiar with them because you've had to go through those processes for a loved one. And again, it's a complicated, expensive proceeding. And this is whether you're in Illinois, California, Georgia, Mississippi. If you don't have power of attorneys, the only way someone's going to be in a position to make decisions for you is to go through the guardianship process. Again, that's complicated and pricey. Here's what's very interesting. We are so fortunate because we have so many long-term married clients, people that have been married for 50, 60, 65, 70 years, I think is the longest married couple we've had the pleasure of serving. About last weekend, I did a home visit for a couple. They were married for 65 years. But inevitably, they are always surprised to learn that notwithstanding the fact that they have been married for 50 plus years or longer, that they cannot make health care nor business decisions for one another without power of attorneys. I'll give an example. Let's say, for example, only one of your names, if you're married, is on something like the phone bill, if you have phone bills anymore. Let's say cable bill. Well, if your name is not on the bill and you even try to call the cable company to find out how much the bill is to make a full payment, they will not even tell you how much the bill is, even if you've been married to someone for 50 plus years, unless your name were on that account. So just think about trying to deal with someone's pension matters, their Social Security matters, some banking matters. Some of you are married and your names may not be on the deed or on the mortgage. It will create a real dilemma for you unless you have the legal authority to be able to make decisions for your spouses. Sometimes some of you are going to need to be in a position to make decisions for your parents, your aunts and uncles, sometimes your siblings. So this information is not just for you, particularly for you ladies who are tuning in today, because ladies are typically the caregivers in our community. And so ladies, if you are looking at someone in your family, whether it's a mom or dad, perhaps a sibling, aunts or uncles, sometimes even grandparents, you want to be in a position to make decisions for them if it ever comes to that. And the way that you get yourself in a position to be able to make decisions for a loved one down the road is by having power of attorneys. Again, there are two kinds of power of attorneys. There's one for healthcare and one for business matter. Everyone needs them both, okay? And what they do is they allow the person, you or your loved one, to name someone to be in a position to make healthcare and business decisions for them if they ever need to do that, if you ever need to make decisions for them, or if someone ever needs to be in a position to make decisions for you. Now, we often get calls from people who need to do power of attorneys for a loved one, but the loved one is no longer competent. So now it is too late because if a person is not competent, they cannot sign any of these legal documents. A person has to be competent to understand what they are signing. So again, we often get inquiries to do power of attorneys and estate planning generally for someone who may have dementia, for someone who is just incompetent. Now, incompetencies is not related to age. You can be, I did a home visit for a lady a month or so ago. She was 99 years old. She was bedridden, but she was very clear about how she wanted her money in her real estate to go and who she wanted to be in a position to make decisions for her. But Alzheimer's and dementia is really prevalent in our community. And the bottom line when it comes to all of this, estate planning, trust for your real estate, and power of attorney for yourselves and your loved ones is, you have to have them before you need them. You cannot wait until you need them, because if a person is not competent, then it's going to be too late, and it's going to create a real dilemma for you to be in a position to make decisions for them. I'll give you a quick example. I had one client whose mom was incompetent, and she had an $85,000 check for her mom. And so she needs to be in a position to pay some of the mom's expenses because the mom clearly had money, but she could not even deposit the check nor get access to her mom's money because her mom was not competent to sign the power of attorneys when she called me. So we had to go through the expensive, complicated probate process to have her appointed as her mom's guardian so she could deposit the check and get access to her mom's money. But again, that was an expensive, complicated process that could have been easily avoided just had she had the power of attorneys before her mom needed them. So you have to make sure that you have both power of attorneys, one for healthcare, one for business matters. I see that we got a question from Derek Hall. His question is, does a dual, D-U-A-L, power of attorney cover both healthcare and business matters? Well, Derek, I have never seen a dual, D-U-A-L, power of attorney. They're typically one for healthcare and one for business matters. There is what's called a durable, D-U-R-A-B-L-E, power of attorney, and that's the one for business matters. And the significance of the durable part of that is it allows a person to make decisions for someone while they are, if they become incompetent. So I've never heard of a dual, D-U-A-L, power of attorney, but there is a durable power of attorney. So there are actually two documents, one for healthcare, one for business matters. The durable power of attorney for a property allows someone to continue to make decisions for a loved one, even if they become incompetent. Okay, so we're talking about estate planning here. I'm attorney Ted London here in Chicago. You can take our name and number. Again, our phone number is 773-721-3333, 773-721-3333. You can always go to our website, tedlondon.org. I have a terrific assistant, Jada. I think I have a YouTube page and I think a Twitter. And so I think we can, if you go to my website, I think we have what's called a link tree. And that will actually show you all of our social media platforms where you can get some information. But we're talking about estate planning here. And again, the objective is to keep your assets out of probate court. Again, for most middle class people, there are really only three categories: the real estate, the individual people, and the money. I don't really spend a whole lot of time on what they call personal property in my estate planning practice. And when we talk about personal property, we're talking about rings, jewelry, fur coats, microwaves, pictures. Here's the bottom line: your loved ones aren't fighting over that 25-year-old Fox stole with the face still on it, like my grandmother used to have. They're not fighting over that. They're not fighting over microwaves. They're not fighting over your sofa with the plastic still on it. They're not fighting over your pictures either. They're fighting over who's going to get the real estate because that's valuable. They're fighting over who's going to make decisions for you because they think that if they get in a position to make decisions for you, they're going to get close to the what? You're right, the money. And then, of course, they fight over the money. So let's talk about the money and how to keep the money out of probate court. And we talk about money, again, we're talking about your financial accounts, checking, savings, mutual funds, 401ks, stocks, bonds, CDs, credit unions, life insurance policies, annuities, safety deposit boxes as well. Well, again, there are two ways to avoid the expensive, time-consuming probate process when it comes to all of those kind of financial accounts. One way is very simple and it's free. And that is just to make sure that you have current beneficiaries on all of your financial accounts. So if you have current beneficiaries on all of your financial accounts, whomever you name as a beneficiary is going to get the money very easily after you without having to go through the expensive, time-consuming, stressful probate process. If you name beneficiaries, your loved ones do not have access to the accounts while you are living. They'll only get access to the money once you go to heaven. Okay. Now, there are some of you who have your children's names on your accounts as signors on your accounts. Well, I would never, ever advise my clients to add their children's names or anyone else's names to your accounts. Because if you add someone's name to your account, that means they become an owner of that account. And that means they can take out any amount of money at any time. And I've seen children and grandchildren take out incredible amounts of money from their parents and grandparents' accounts. They're just unbelievable amounts. So I'm always against adding your children's names to your accounts. Here's another reason why I'm against you adding your children's names to your accounts. Because if you add your children's names to your accounts, if your children are ever sued, they can collect that judgment from your account, okay? Because they are now an account owner. And the court's not gonna be concerned about who put what in that account, even though you probably put all the money in that account. If you add your children's names to your financial account, if they are sued, money can be collected from that account. So please don't do that. But you do wanna make sure at least that you have current beneficiaries on every single financial account that you have. And the reason why I'm so adamant about current beneficiaries as opposed to just saying beneficiaries is because we see many people after they pass away, it is discovered that they've had people on their accounts that have already predeceased them, people that they aren't married to any longer, people that they didn't even like anymore, people that they haven't spoken to in years. So you have to make sure that your beneficiaries are current. I'll give you a couple of examples of that. I had one client that came in. Her husband passed away unexpectedly one day at work. He was 48 years old. He worked for UPS, and he passed away at work unexpectedly. She had been married to him for 8 years, and he had previously been married. He had a $500,000, $500,000 life insurance policy, but he never changed the beneficiary from the first wife. So the first wife got the $500,000 lump sum, tax-free, nothing that the second current wife could do about it at all, okay? And believe me, she was not happy, okay? So you wanna make sure that, I give you another example. I had one client, he was a retired police officer here in Chicago and had never been married, no children, and he had his mom on as a beneficiary. Well, heck, he passed away, he was 90 years old when he passed away, so his mom had long predeceased him. He had one sister who was going to be the heir, and so she had to go through the probate process to collect the money. Well, she had to pay a significant amount of money to probate his estate for her to collect a significant amount of money. But had he only updated his beneficiary to his sister or whomever he would have wanted to have the money, they would have not had to spend one nickel to collect the money. Now, as the lawyer that handled that estate, I'm grateful that she retained me to probate her brother's estate and to collect the money. I was grateful for that, but again, it could have saved a tremendous amount of money had he just updated his beneficiary once the mom passed away. So as a result of having this kind of seminar here, I'm encouraging you to, one, make sure you have current beneficiaries on all of your accounts. And this is a good time to go and really double check. I had a client in my office yesterday, and he had done some estate planning, and I asked him, well, can I review it? Please let me review it. And he had been in my office about 3 times, and each time he was saying, no, I already did it, it's already done. But he was giving me kind of contradictory information. He was with his wife. And so finally the wife said, well, just let him just review it. So I did. And as it turns out, all the things that he thought he had changed was not changed. Okay, so estate planning is not a DIY, do-it-yourself project. You have to have a professional to do these things for you, because when your loved ones are counting on them, they have to be done correctly. I can't tell you how many times I've seen people who have tried to do these things themselves and they are done improperly. And then when the loved ones need them, they are void. So, so make sure you get a professional to do these things, this estate planning project for you. But when it comes to the money, keeping the money out of probate court, one way is to make sure that you have current beneficiaries on all of your financial accounts. For others of you, you may need what's called a living trust. Now, not everyone needs a living trust because living trust can be a little slightly more pricey than just a land trust for those of you who are local here in Chicago. But here are the people that should consider investing the additional fee in what's called a living trust versus just having beneficiaries on all of your financial accounts. Well, one, if you're leaving money to special needs loved ones who may be collecting SSI benefits, then you would need to set up a living trust to leave them that money. Because if you left that loved one who's getting some SSI benefits, for example, the money directly, it would cause them to lose their SSI benefits. But if you leave the money through a living trust, they can actually get the benefit of the money that you're leaving them and still get the benefit of the SSI benefits. Give an example. I had one client who's a retired educator. She has one son, special needs. He gets SSI benefits. And so she wants to make sure that he's going to always be able to live in a home and he's always going to get his SSI benefits. So we set up a living trust for her. We named someone who's going to manage the home for him. And we named someone who's going to manage the money for his benefit and who's going to pay the taxes on the home and the upkeep, those sorts of things. But the big thing is her son's going to get the benefit of her money and not jeopardize his SSI benefits. So one reason why you would want to have a living trust to keep your money out of probate court is because you're leaving it to someone with special needs that's collecting SSI benefits, and you don't want to jeopardize their SSI benefits. Another reason why one would need to do a living trust is if you're leaving money to minor children. Many of our clients have a deep, deep love and affection for their grandchildren. And so they often want to leave money to their grandchildren. Well, you can't leave money to minors on your life insurances and your financial accounts because they cannot collect the money. If you leave money to minors as beneficiaries on your financial accounts, what's going to have to happen is their parents are going to have to go to court to be appointed their guardian to collect the money. And then that money is going to go into a court secured account that no one's going to be able to touch until the kid is 18. And then the kid will get the money at 18. And normally, you don't want your kids to get a lump sum money at 18 because by the time they're 19, they're going to be broke. So if you're leaving money to minor children to help fund their college education or whatever you want to accomplish, you want to leave the money through a living trust, not as named beneficiaries on our financial accounts. Another reason why one would want to have a living trust as opposed to just leaving their loved one's money as a named beneficiary on financial accounts is because many of our clients have done really well for themselves and they don't want to leave their adult children money in a lump sum. And so if you don't want to leave your adult children money in a lump sum, then you would need to have what's called a living trust. And with the living trust, you get your name, who's going to manage the money, and you get to determine the conditions that the children are going to be entitled to the money. So typically a living trust would go something like this. I'll give the kid $25,000 a year for 5 years, or until they turn 30 or 35, whatever it may be. And then at the end of that term, they'll get the whole amount. I'll give an example of a living trust that we did for a family. Husband and wife were both retired educators. They had done really well for themselves. As I recall, they had about $3 million. And they had twin boys. Both the boys were good boys. One of the sons he was an educator as well. The other was he was in the military. He's a pilot, some officer in the military. Very proud of both of their sons, but they did not want the sons to get the money in a lump sum. So we did a living trust for them where, as I recall, the boys were each going to get $100,000 per year for 5 years. And after the fifth year, whatever was remaining in the trust, they were going to divide equally, and they were going to be able to take it in a lump sum, which, as I recall, was going to be about $1 million each. So they were going to get $100,000 for 5 years. The 6 years, they were going to divide whatever in the trust, which was roughly about $2 million, according to my calculations, as I remember. And then the boys were going to get $1 million apiece after the fifth year. The mom was the one that was really adamant about that, because she thought, well, we'll walk them into getting the money. We don't want to give them just $1.5 million a lump sum. Let's give them $100,000 per year, and then by then hopefully they will have been accustomed to managing this kind of money, and they won't go through it so fast. So that's an example of a living trust. Another example of a living trust that we may do for minors is we may do a living trust for a minor where a grandparent or parent wants to fund a college education. So we may give the student at the age of 18, $10,000 or maybe $25,000 per year for up to 5 years for college, as long as they maintain a B average. And typically, I've asked my clients to give the loved ones maybe another $25,000, $10,000, whatever that number is upon graduation. Give them another amount at 25, and then maybe pay them out at 30. Sometimes we'll pay them out at 40. Okay, so that money can last really from 18 to as far out as 40 with a living trust, as opposed to if you just name them as beneficiaries, they'll get the money in a lump sum. So many of our clients do living trust because they don't want the children to get the money in a lump sum. So the reasons why one would need a living trust versus just making sure that you have current beneficiaries on all the financial accounts are: one, if you leave the money to special needs loved ones; two, you leave the money to minor children; or three, you just don't want your adult children to get all the money in a lump sum. Okay, so typically if you're a middle class person, that's a comprehensive estate plan to keep the real estate out of probate court, to keep yourselves out of probate court, and to keep the money out of probate court. For the real estate, it should be in some sort of trust. In Illinois, Chicago, we put in a land trust. Some of you in some of the other states will use what's called a living trust. We have many clients out of state, so some of you are out of state. I know we can still service you. We have a lot of clients in California, DC, we require more clients in the Houston and Dallas area. And you know what, we have quite a few clients in Mississippi. Part of the reason for that is many Chicagoans originally came from Mississippi, and a lot of them still have property in Mississippi. Some of the property is air property, which is very complicated because it has not been unraveled. Some of them have property that has been already probated from their parents or grandparents, and they have their 5 or 10 or 25 acres. And then we arrange it for them to leave their share to their children. But if the property is still, if we're talking about property typically in the South, Arkansas, Mississippi.
Which if ignored can bring you here.
Typically, if there's property in the South that's in the grandparents' name, there's nothing we can do about that property until that property has been probated and has been subdivided between the heirs.
There's never been a
So
better time.
let's do a recap. So the recap is we're talking about estate planning, and the whole objective of efficient estate planning is to avoid probate court. Probate court is expensive, it's time consuming, and it's stressful. So we don't want your loved ones to have to go through the probate process once you pass away. Some of you are very familiar with the probate process because you've had to endure it. In that regard, we don't do wills, because if you have a will, then your loved ones will have to go through the expensive, time-consuming, stressful probate process. So believe it or not, rule number one for efficient estate planning is no wills. For most middle-class people, again, there are 3 primary things that we want to keep out of probate court: the real estate, the individuals, you and your loved ones, and the money. So for the real estate, put a land trust, you get your name who gets it after you. They'll get it very easy without going through the probate process. Has some other benefits as well. It's going to stop the judgments from attaching if you're sued, and it's going to offer you a privacy benefit. No one's going to be able to research your name and find out what you own. They're not going to be able to research your property and find out that you own it. Another benefit of the land trust as well is it cuts down on the risk of property fraud. Property fraud is really prevalent these days because all someone has to do is just prepare a fraudulent deed and record it, and then they own your home and you don't even know it. I had a client that her dad had passed away. He was a physician, and then the mom had passed away, and then so the siblings were going to sell the home. This was in Michigan, and when they went to sell the home, they only discovered at that time that someone had recorded a deed to the family home. Now we were able to get that deed vacated in reverse because they signed the dad's name 3 years after the dad had passed away. And so that was easy to invalidate that quitclaim deed, transferring it to this one person, and they were able to recover the property because and sell it. But they still lived in the property, so it was just a paper switch. It wasn't a control of the property that the guy had. He owned it on paper. So if you have your property in a trust, that does cut down on the risk of property fraud as well. So all real estate should be in a trust. Secondly, everyone needs power of attorneys, one for healthcare, one for business matters. You need them for yourself. You need to make sure whether you are single, and even if you are married, you need to have them for yourself and for your spouse. And again, there are two. There's one for healthcare, one for business matters, where you are naming a primary and you get to name a secondary person as well to be in a position to make decisions for you if you ever need someone to make decisions for you. Again, you can't wait until it's too late to do them because, again, if a person is no longer competent, then it is too late. And you have to go through the probate process to be appointed someone's guardian. Again, to you ladies, you ladies are caregivers, and you are the ones who are caring for people in the Black community, whether it's your parents, whether it's a sibling, whether it's an aunt or uncle, so you have to look down the road too and make sure that if you're seeing someone that you're going to need to be in a position to make decisions for, make it easy for yourself and make sure that you have the documentation that legally authorizes you to be able to make healthcare and business decisions for them. Really, really, really important, because there's nothing more frustrating than needing to be in a position to make decisions for someone, but you just don't have the standing to do it. And if the person is no longer competent, then it's too late, and you have to go through the guardianship process, very complicated, very expensive, but it's very easy to avoid just by having the power of attorneys, okay? Finally, you wanna make sure that you're gonna keep your financial accounts out of probate court, checking, savings, mutual funds, 401ks, stocks, bonds, CDs, credit unions, life insurance policies, annuities, safety deposit boxes. One last thing, even your hidden accounts. I had a couple in my office yesterday, and it turns out that that the husband had a hidden account, and wife didn't know it. And I hate to admit this, ladies, and I hate to tell on us gentlemen, but as it turns out, men have more hidden accounts than ladies. So ladies, you do have to really get to the bottom of your husband's hidden account. Tell them, keep the hidden account, but just can you make sure that you have a named beneficiary on it and make sure that we know where it is? Because if you cannot find the account, and if your loved ones cannot find the accounts, they cannot collect the money. So we give our clients what's called an estate plan and inventory book, where your loved ones list all the account information so your loved ones will know where they are at the appropriate time. Now, you don't have to list the balances, but your loved ones do need to know what the accounts are, what the account numbers are, who the beneficiaries are, so at the appropriate time, they can collect the money. More and more money is being lost and going to the state, and your loved ones are not collecting the money because so many of you are doing online banking now, and so you're not getting the monthly statements. And so it becomes even more difficult for your loved ones to collect the money. I've researched this topic, And about 3 or 4 years ago, it was about $6 billion throughout the country that loved ones were not collecting because they just didn't know where their accounts were. I researched it maybe 2 or 3 months ago. It's up to $9 billion that your loved ones are not collecting because when people are going to heaven, the loved ones don't know where their accounts are. And we get those calls all the time. My mom passed away, my dad passed away, my husband, wife passed away. Can you help me find the accounts? And the answer is no. So if your loved ones don't know where the accounts are, they cannot collect the money. And because again, so many of you do it online banking, there was a time when I would advise my clients to just watch the mail because you'll be getting statement in once a month, maybe once a quarter at least. But I can't even offer that suggestion anymore because so many of you are doing online banking. So it's very important to make sure you have current beneficiaries and that your loved ones know where your accounts are. Or some of you may in fact need living trust. Again, the living trust do come with an additional cost, but here are the considerations that would determine whether one needed a living trust or if just named beneficiaries on your accounts are going to be sufficient. Well, one, if you're leaving money to special needs loved ones and you don't want to jeopardize their SSI benefits, you should have a living trust. If you're leaving money to minor children, you cannot leave minor children as beneficiaries on the account because they cannot collect the money. You should have a living trust. If you're doing well for yourself and you don't want your adult children to get the money in a lump sum, you should have a living trust. Even our clients that have children with some substance abuse issues, mental health issues, they still love their children and they still want their children to be takers in what they have acquired over a lifetime. And so for those, we set up a living trust and someone manages the money for them, but they still get the benefit of the monies that their parents or loved ones earned and accumulated without it being at risk of just being lost haphazardly by someone with a mental health issue or substance abuse issues. Other miscellaneous things like cars, typically if my clients have cars that are paid for and you have the titles to the cars, I like my clients to sign the titles and put them in a safe place. So at the appropriate time, whoever's going to be entitled to it will just sign their name where it says buyer, take it to the Secretary of State's office, record it, and then they'll get the car very easily. Mentioning safes, some of you have safes. Many of our clients have safes these days as opposed to safety deposit boxes. So if you have a safe, it's very important that someone has the key or the combination to access the safe, because if they don't, they're going to have a very difficult time accessing the safe because some safe companies will require that the loved ones go through the probate process and someone is named the administrator of the estate for them to even open up the safe. Okay, same thing if you have a safety deposit box. Unless you have someone on that safety deposit box, your loved ones are going to have to go through the probate process to access it. And then they'll spend all this money thinking that because there's a safety deposit box or a safe, they know you have millions in there because they know you have millions anyway. Here's a quick secret for all of you. When you pass away, everyone thinks you have millions of dollars. I don't know why that happens, but even if you were homeless at the time, they just thought because you were homeless, you weren't paying any rent, didn't have a mortgage, you must be rich. And if you have a safety deposit box, they're just going to be certain of it. But the only way they're going to be able to access it, unless you add their name to it, is go through the probate process, pay some lawyer a bunch of money to get access to the safety deposit box, and then open it up, and voila, what's in it? Bunch of old papers, a bunch of old deeds, a bunch of old pictures, and no money, and then they're mad. So if you have a safety deposit box, be sure to add someone's name on it or as a beneficiary. Again, I have a couple other miscellaneous concepts. I have a concept that I coined as giving while living. And that concept basically says some of you have done really well for yourselves, and you don't have to wait until you pass away to pass some of your assets on to your loved ones. One of the things that I encourage our clients to do, and I do a radio show here in Chicago as well on WVON 1690 AM. I do it every Thursday, so I'll do it today at 3:30. And one of the things I encourage, so if you can tune in, you can tune in for those of you out of state on iHeart Radio as well. That's WVON 1690, 3:30 until 4 Central Time. That's a show called The Legal Line. But I encourage my clients to help their children buy a home. And so if you can give them 10,000 or 25,000 on the down payment on a home, that's going to really be beneficial. And you don't have to wait until you pass away to do that. And do you know what the benefit of that is? You get to go over their house for Thanksgiving and Christmas and not your own. So the grandkids can mess up their own houses and you can just go back to your own home and don't have to wash dishes and all that kind of stuff. I got a call from a client who listened to me on WVON on my radio show, The Legal Line. And she told me she was giving her son $100,000 down payment on his home. And he didn't know that she was going to give it to him. She was so proud of him because he got the home on his own. He qualified on his own. He can afford the home on his own. But she said that she had listened to me on the radio show, encourage our clients to implement the giving while living strategy of giving. And she decided to give him $100,000 and he's going to be very, very, very happy about that. So you don't have to wait until you pass away to pass some of the things along. Some of these things, a lot of our lady clients, for example, tell me they don't wear their jewelry as much as they did. So if you don't wear your jewelry as much as you did, and you know you want to go to someone in particular, you can just as well give them the jewelry now, and you can see them wear it and get the benefit of seeing them enjoy it. And then you know what happens as well? You get more hugs, you get more kisses, you get more calls, you get more drive-bys of the kids and the grandkids coming over and hugging you and kissing you and calling you and all those kind of things because everyone just loves presents and gifts and those sorts of things. So if you can afford to, we don't want you to hurt yourself financially, but if you can afford to, do a little bit of giving now and again, get the benefit of the hugs and the kisses and the drive-bys and the calls that you can't get when you're in heaven. So that's a tip for the day. I coined that as giving while living. We have a question here. Let me read it. It says, when purchasing property insurance under a land trust, must the land trust document be shared with the insurance company or will providing the trust number suffice? You know what, Ms. Deborah, that's a good question. So Ms. Deborah was asking if you have your property in trust and you're getting property insurance, will the trust company need the trust documents or will the trust number suffice? You know what, Ms. Deborah, that's going to be every insurance company and office is have their own specific requirements. Some of them will require the trust documents. Others will require the trust agreement. For others, the trust number will be sufficient. So that's really a specific question relating to the insurance company and the insurance office. All of them manage the things just slightly different, but whether it's the trust number or the trust agreement, if they need either of those, that's really a seamless process. So it's not really too much to email them or fax them over a copy of either. We want to invite you to ask questions. I think my assistant Jada's here, and I think she's taking questions. You can raise your hand, and you can raise your hand, and I think Jada will unmute you, and you can share the question, or I think you can type it in the chat. You can type it in the chat box, and I can read it, and then I'll answer. But estate planning is so important to the African American community. Because so many of our homes are being lost in the inner cities. And the homes in the inner cities, 30 years ago, people bought these homes and they worked hard to acquire them. They paid for the homes. And at the time, they may have paid $35,000, $35,000 to $50,000 for the homes. Now they're worth $300,000, $350,000 or more. And with no mortgages on them, that's real money that you're leaving to your loved ones. You know what, there's a lot of conversation about generational wealth these days. Well, if you leave a home worth $300,000, yes, you are leaving generational wealth, but you want to do it in an orderly fashion. You want to avoid probate court for your loved ones. And you want to make sure that the property and your money goes to the loved ones that you want it to go to, not to someone that the court's going to required to go to because you didn't have some estate planning. Here's a question from Mrs. Pratt. My godmother made a will out previously and she's been placed in a hospice. How do I find out about it? She doesn't remember the attorney's name. That's a very common scenario. So Mrs. Pratt is saying that her godmother has a will. I'm going to presume that she cannot find the will and she doesn't know the attorney that prepared the will. Well, let me give you a bit of information. When we do estate planning for our clients, we don't keep the documents. We give the original documents to our clients. So even if you found the lawyer who did the will, he or she may or may not even have it. So if a person presumably has a will, and if the will cannot be found, then the person would have passed away as if they did not have a will, which is going to send the things through the probate process. Now, even if there were a will, we already learned that it's still going to have to go through the probate process. The difference between having a will and no will and going through the probate process is with the will outlines who's going to be entitled to the assets. You still have to go through the exact same probate process as if you did not have a will. The difference is if you don't have a will, then the state determines who's going to get your assets. Typically, it's going to be a spouse or children. So, but you still have to go through the exact same probate process. Mrs. Pratt, here's what I also just let you know. Just because godmother is in hospice, that doesn't necessarily mean she is incompetent. If she is still competent, you can still do estate planning for her. Okay, so that would supersede the will. So even some of you even may have wills, you can still do a trust and it will supersede the will. Okay, so if godmom is not incompetent, then it is not too late to still put her property in a trust and see if we can get some beneficiaries named on her financial accounts as well. Got it. Oh, she's no longer competent. Okay, so that's unfortunate. So because the person is not incompetent, then there's nothing you can do. If you can't find the will, then that means she would have passed away without one. That's the presumption. And then the courts or the state's going to determine who's going to get her assets. It's going to be typically children, spouse, could be potentially grandchildren. If there are none of those, then it will go to her siblings, brothers and sisters. If there are none of those, aunts and uncles, on down her bloodline. But the further down you go in those bloodlines, the more pricey probating her estate is going to be, because you're going to have to try to discover some of those heirs. But if you can't find the will, the bottom line is the person would be presumed to not have one, and then the assets will be distributed according to the laws of the state that the person is in. In Illinois here, it's spouse and children, no spouse then children, no children then grandchildren. If none of those, then siblings, and on and on and on down the bloodline. Anyone have any questions? I appreciate you all for joining in so much this morning. I'll give you our phone number again. Phone number again is 773-721-3333. You can go to our website, tedlondon.org, and we do have a link tree there. And on that link tree, it will show you, I guess, all our other social media accounts. I have a young person managing this for me, so I don't know all of it, but I'm thinking I'm saying it right. It's a link tree, and that will show you all our other social media platforms. And we have some seminars on there as well that you can review, and you can advise some of your loved ones to review and to get some information as well. Again, I do the radio show every Thursday on WVON 1690 AM. So that's going to be today. You can tune in. It's from 3:30 until 4. It's a segment called The Legal Line, and we talk about these same sort of estate planning and probate issues on the radio show. That brings me to another point. I know some of you are probably asking, what is probate? What is probate? We get that question a lot when I do seminars and people are asking, because I talk about avoiding probate court, and people ask, well, what is probate court? Many people don't know. Well, probate court is a process that if someone passes away and they don't have estate planning And if they have a will or no will, then you have to go through a court proceeding that's going to validate the will if there is a will, or validate the heirs if there are no wills. Have to hire a lawyer. There are filing fees. You have to get a bond. There's an assortment of other fees as well. And of course, there's fees for the lawyer, and they're not inexpensive. Typically, the court in my jurisdiction here in Cook County, the court gives you 18 months from the time that you open the estate to the time that you close it. But rarely can you close in a probate matter in 18 months. So normally it's going to go 2 years, 2.5 years. Here's another downside of having a will or your loved ones having to go through the probate process. If they have to go through the probate process, the deceased person's creditors can make a claim on the estate. And that's for healthcare expenses, Medicaid expenses, doctor's bills, credit cards, whatever it may be. If they make a claim on the estate, they're going to be paid first. That is those creditors. They're going to be paid first, which will diminish what the heirs would be entitled to. If you keep your things out of the probate process by having a trust, beneficiaries in all your financial accounts, living trust for some of you, your creditors don't get an opportunity to make a claim on the estate, and that's going to ensure that your loved ones get the full value of your estate. Let me give you another quick scenario. I had another a client, she and her husband were both educators here in Chicago, young people. He had COVID, passed away at 45 years old. His name was the only name on the home, and he had about assortment of accounts with roughly $250,000 in the accounts. No beneficiary on the account. He's 45. 45-year-olds are not doing estate planning things. 50-year-olds are not doing estate planning things. 60-year-olds are not doing estate planning things. 65-year-olds, they're not doing estate planning. 70-year-olds, maybe. 75 more. Our average client is ranging in the age of 80 years old. Yeah, it is true that people are living longer and they're living healthier lives, but I would certainly like to see our clients come in. When I initially started doing estate planning, I thought our clients would be coming in at 65 years old. The 65-year-olds are not coming in to get estate planning. I'd like to start seeing our clients coming at 70, 72 years old, or something like that, but before 80. But so many of our clients are 80, 82, 85. Again, I just told you I was at the client's house a couple of weeks ago, and the client was 99 years old. But in this case, the husband passed away, 45, a retired educator, had about $250,000 in the account. A home is only his name, not the wife's name. So when he passed away, we had to go through the probate process. Well, he also had $150,000 in student loans. And so when he passed away, the student loan company made a claim on his estate, and they were going to be entitled to the full value of the debt. We were able to negotiate the debt down from the $150,000 to only $75,000. So reduced the debt by 50%, but that was still $75,000 lost because he didn't have beneficiaries on his accounts or a living trust, didn't have the home in a trust. So had he had the home in a trust and beneficiaries on his accounts, the wife would not have had to go through the probate process, and the creditors would not have been able to make a claim. So that's another reason why you want to avoid probate, because you want to avoid creditors from making a claim on one's estate. Let's see, another question from Mrs. Pratt. I previously attended a seminar that you hosted at your school and filled out a fraud alert form, and recently I did a modification, received a notification from the city. Oh, thank you for the information. So that's just a thank you. That's just a thank you note from Mrs. Pratt. Thank you very much, Mrs. Pratt, for attending. Ms. Jada, do we have any other questions or any other calls? We have.
Yes, Ms. Harmon has a question. I'm about to unmute her now.
Okay, please do. Jada is our
Okay,
social media expert, so she
okay,
is coordinating all of this. Yes, yes.
okay, good morning.
Good morning.
Okay, I had a trust done about, with you about 6 years ago.
Okay,
And I would like to change the name on the person who received my property.
okay.
Power, yeah. So how do I go about doing
Just
that?
use a separate time to come in, Ms. Essie, and we'll update it for you. We can update your power of attorneys for you if you care to, and we can update the beneficiaries on your land trust as well. And that,
Oh, okay.
Ms. Essie, thanks for that, because that brings me to a good point. I appreciate you all, because you're all so smart, and all of your questions leads me to maybe something I forgot to tell you. But one of the benefits of having a trust is if the person that you named to get your property after you gets on your nerves, you can change them very easily. So just because you name someone to get your property after you, you're not stuck with them. If they get on your nerves, if you don't like them, if you divorce them, you can change them very, very easily. So Miss S, you just call, make an appointment to come on in, and we'll change it for you.
Okay, thank you.
Yes, indeed. Miss Jada?
That's all the questions we have for now.
Does anyone have any other questions at all? Any other issues that I can discuss? No, keep in mind, we do this seminar every first Thursday at 11 o'clock, same time, same station. So, you can invite some of your friends to tune in so they can get some information as well. Sometimes people need to hear the information more than once. So you can always feel free to tune in yourself again. You can always call our office, again, at 773-721-3333. Our office is at 1718 East 87th Street here in Chicago. You can go to our Google, you can Google Ted London. We have a link tree, so we have other social media platforms with a lot of information on that as well. Another thing too is, I don't talk about this that much, but we handle quite a few serious car crash and truck crash cases. And I know so many people associate law office of Ted London with estate planning and probate, but the fact is we handle a significant amount of personal injury cases, nursing home abuse and neglect cases, again, truck cases and car crash cases, which are really proliferating all over Chicagoland, really all over the country. More people are driving fast, reckless on their phones, and so there's so many car crashes occurring, and our office is very busy representing many seriously injured people in some of those kind of cases, and nursing home abuse and neglect cases as well. So just keep that in mind. If you have loved ones that have been involved in a car crash or a truck crash incident, or if you have a loved one that there is some nursing home abuse or neglect occurring, you can always call our office for some information as well. Well, I think that wraps up my time. If there's no other questions, you can always call our office. I'm so grateful that you all tuned in with us this afternoon. And again, some of you may be shy and may not want to ask the questions on the chat here, on the Zoom here, but you can always call our office anytime. Again, 773-721-3333. Thank you all so very much for joining us today, and tune in this afternoon if you can, 3:30 until 4, WVON 1690 AM. Again, those of you out of state, you can always go to iHeartRadio, coming very clearly, and we'll hope you join us there as well. Thank you so much to everyone.